Hall and Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome back to our podcast, Tax Records. In this series, we're examining the hot topics in taxation. My name is Todd Bromwich and I'm a special counsel at Hall and Wilcox. And today I'm delighted to be joined by my friend and colleague and head of the tax team, Frank Kanopoulos.
Thank you very much, Todd. Nice to be with you again for another podcast, and it's certainly nice to hear you refer to me as your friend. I do wonder sometimes, given the way you treat me, but very reassuring.
Getting ready for the next performance review, getting in with on the front foot. So in today's episode, we're going to be discussing managing tax risks for globally mobile clients. This is an issue, or these are issues that come up pretty regularly in our practice, and we're finding that it's becoming more and more relevant for our accounting referrers as they take on bigger clients and, their current clients or the next generation moving to and from Australia. It is just becoming an increasing area for them to focus on. So to kick us off, Frank, can you just give us a quick overview of what's the current landscape in Australia and where are the main tax risks for private clients who might have a bit of global mobility for themselves or a member of their family?
Yeah, thank you, Todd. And this is certainly an area that you and I do a lot of work in and is a growing area of practice for us, giving advice to cross-border and globally mobile clients about managing their tax risk in Australia. So in terms of the landscape in Australia and what some of the sources of risk are for private clients, especially in the offshore or cross-border environment, we've said it before and it's worth saying again, the ATO has a clear focus on high wealth individuals and privately owned groups, and that is especially so where there is global mobility or ownership of assets in more than one jurisdiction. Again, we've said it before and we'll say it again, the ATO has a close compliance focus on family trusts, on financial arrangements, and in particular on dealings between Australian residents and offshore parties. People moving around the world from Australia to other places or from other places to Australia is a really big issue that's going to always trigger a lot of complex questions around residency, and we talk a bit about those later on. And as much as people moving around causes tax issues, certainly moving money or assets around also causes tax issues as well. So, it's very often the case. We see it all the time. We read about it in the paper. People from overseas or people in Australia receive money from overseas. There's always going to be a question about what the source of that money is, whether it's sourced in income or has the character of income, and where it's gifts or loans from family. It's important that that's documented. Moving money out of Australia, care needs to be taken to ensure that there is compliance around that, and especially so where family trusts are involved or where it involves distributions from family trusts. And the other thing it's important for our audience to know is that obviously moving, even not significant amounts of money between countries into Australia or out of Australia is something which does attract attention. And many of the people listening to us today, Todd, would know that, for example, cash transactions of 10,000 AUD or more are notifiable to AUSTRAC. And that is something that can very often be the trigger for the ATO to have a closer look at what a client has done and ask a few questions, and may very well lead to a closer ATO examination or even an audit.
Thanks, Frank. That's a good overview to kick us off. Just going into a bit more detail now, you mentioned that tax residency is a big issue, and that's certainly the case in my experience. Can you give us a quick overview just of how tax residency is determined in Australia? Because we find there is a bit of, I wouldn't say misinformation, but maybe a misunderstanding of how tax residency is determined.
Sure, Todd. Well, it's no news for me to say that tax residency is hard. Working out whether a person is a resident of Australia or a resident of another country or even both these are hard tax questions and hard legal questions. I always say that it's one of the areas that people litigate about in court quite a lot. There are lots of cases that are heard in the AAT and the federal court about residency issues. And I often say that the complexity of these questions is illustrated by the fact that quite often, a tribunal member or a judge will reach a decision based on the facts about a person's residency status, and then another judge hearing that same case on appeal might completely reverse that decision and come to a different view, showing that even judges or tribunal members can disagree with each other about how to apply the law to determine a person's residency. So this is a big topic, but to sort of just give our listeners a couple of pointers and some broad principles. In Australia, quite differently to what is the case in other countries, being a tax resident is not linked to citizenship, being Australian citizen, or to visa status, although these things can be relevant factors that can impact whether you are taxed as a resident or not. You need to think about residency issues for individuals, for companies, and for trusts. For individuals, the residency test depends on whether a person is a resident according to ordinary concepts. That's a pretty hard thing to conceptualise because the legislation doesn't tell us when a person is ordinarily resident in Australia or where they're not. It's a factual question, and you have to weigh up the facts and all of the relevant factors and make a determination or a judgment on balance with which country a person has the closest connections with, Australia or somewhere else. There's the domicile test, which basically plants you in Australia as an Australian resident unless your usual place of abode, meaning the place where you usually live your day-to-day life, is outside of Australia. That's another sort of complex concept that goes back it's quite a historic concept. And then there's the physical presence in Australia test, which is if you're in Australia or spend more than 183 days in Australia during a financial year, that there is a presumption, a rebuttable presumption, but a presumption nonetheless, that you are a resident unless an exception or an exclusion applies to you. So that's the case for individuals. For companies, it gets, it is as, if not even a little more complex to work out when a company is a resident of Australia. So looking at it through an Australian lens, a company will be resident if it's incorporated here. That's pretty basic and pretty obvious. And if a company is not incorporated here, if it's incorporated in another country, it can still be Australian resident where its central management and control is based or exercised by people in Australia. This is an area, company residency, where there's been a lot of movement, where the law is complex, and where it can have some really serious implications or repercussions for taxpayers. And we are dealing with a few live issues that are in an audit environment right now that are about company residency. And the final thing I mentioned where residency becomes important is around the residence of a trust. Now, for trusts, it's really important, and I think the key message that certainly you and I always hammer home, Todd, is that a trust, wherever it's been set up, wherever it's been established anywhere in the world, can be an Australian resident trust if a trustee is an Australian resident. And the emphasis there is on the singular, Todd. So you only need one trustee, even if there are others that are not Australian resident, for a trust to be determined to be a resident of Australia. So that's a snapshot. Obviously, these things and these questions can become very complex, are very complex. They're very factual. The facts matter as much as the law. And often what happens is that a person, a trust or a company can be, under the domestic laws of Australia and another country, a resident of both. In which case, it's often necessary to open up a double tax agreement and look to tiebreaker provisions, which can just lead you down a whole different rabbit hole. And really, it is hard to land on a very clear answer for these things a lot of the time.
Thanks, Frank. Those tests all seem to be based on circumstances that might change from time to time. So particularly where someone's in a job that can be done anywhere in the world, or if their income is from, say, investments and they don't have a job in the traditional sense. So residency might change year on year. what should our Australian clients consider when they might be thinking about making a move overseas?
Sure, Todd. Well, again, you and I talk to clients about this a lot, and what we always tell them is that it's really important to start their planning and thinking about these type of issues as early as possible. And it's never a good idea to let the facts happen. For a person to move out of Australia or move into Australia, and for them to come and see us a couple of years later, after all of the facts have been set and can't be changed from that point in time, because they may well have caused tax consequences for themselves that they weren't expecting or anticipating or hadn't planned for. So getting ahead of the issue early and planning the issue early is really important. And as much as possible, we encourage our clients to try and think that way and do that. Following on from our earlier discussion, whether a person can leave Australia and even leave Australia for a long period of time and not change tax residency. A person could spend a lot of time overseas and keep a close enough connection with Australia that they are still considered an Australian tax resident, meaning that their income from anywhere in the world would remain subject to Australia's tax net. So, it always depends on the circumstances, and people shouldn't, fall into the trap of thinking that just, not being physically present in Australia for a period of time, even a considerable period of time, will cause a change of tax residency. Another important message is that whether it's a person coming into Australia or a person leaving Australia, the fact of an individual changing their residence can actually have a knock-on effect on the residents of structures like companies, like trusts that they control. So it's a scenario that we see a lot, where a person might come to Australia and commence residing in Australia as an Australian resident person. Before they came to Australia, they had set up companies that ran businesses or did other things overseas. It is often the case that the fact that a person becomes Australian resident can mean that those companies, trusts, or other structures can become Australian residents as well. And that can really cause all manner of complicated tax and practical issues for that client. There's also, and this isn't always clearly appreciated, but there are also CGT events that happen when a person stops being an Australian resident, and they can be pretty hard and complex to navigate. Leaving Australia and ceasing to be an Australian tax resident can be a CGT event that can cause capital gains tax. And if that's the case, if a capital gains tax liability does arise, then it's effectively an unfunded tax liability, because there's a liability but no cash. You haven't sold the assets to anyone. You've effectively just you've changed the deck chairs on the same ship. So those CGT issues can be managed. You can manage those things to defer those types of outcomes, but you want your client to be in a position where they can make choices. And there are a raft of other issues as well that can arise. And I think the key to it is early planning, early thinking about these issues, and having a real strategy and a plan to manage these things.
Thanks, Frank. That covers individuals who are moving overseas. What about the opposite? What if we've got foreign residents who are thinking about relocating to Australia?
Sure. No, thanks, Todd. And I have touched on some of these issues as well in my previous response. But again, the question, when a person relocates from overseas into Australia, the question becomes whether they have become an Australian resident, and importantly, at what time they have become an Australian resident. And again, that becomes a matter of assessing and forming a judgment based on the facts. When a person, again, there are also, like there are CGT rules on the way out, there are also CGT provisions that are relevant on the way in. So when a person comes to Australia, for CGT purposes, they can set a cost base in their assets, in the assets that they own, when they move to Australia. And it's actually, the legislation requires you to be pretty precise and identify a point in time when a person becomes an Australian resident. But what happens there is that when a person moves to Australia and becomes an Australian resident, their assets from offshore may be rebased to their market value on the date that they become Australian resident. And that's the cost base that that person will take forward then for CGT purposes if they eventually realise those assets as an Australian resident and subject to the Australian tax jurisdiction. Importantly, if you become an Australian resident, then you submit fully to Australia's tax jurisdiction. So that means that a person's income, including capital gains, wherever they make them, anywhere in the world, will be subject to Australian tax. And again, drawing on the point that we made earlier, if a person is in Australia and they are a person who has a controlling role or a controlling function in relation to an overseas structure, like a company or a trust, the issues can become even more complicated around not only the residence of the person, but the residence of some of the structures, like a company or like a trust, that they have an interest in. And as I said before, that can cause all sorts of complex compliance and tax issues for those taxpayers.
Okay, Frank, can you just tell our listeners a bit about those complex ongoing tax and compliance issues you mentioned when it comes to maintaining offshore companies and trusts? What's the issue if the income is just retained in those structures overseas?
Sure, Todd. Well, they are complex issues, and we could fill hours and hours of time talking about them, but there's a couple of things that are worth flagging. The first is it would be a mistake to think that just because income or assets are offshore or have been generated offshore or even are left offshore, that they are outside of the Australian tax net. I mean, we have rules in Australia, which we generally refer to as the provisions, that, and the way that those accruals provisions apply is that they can make an Australian tax resident taxable on income that has been made by an overseas company, which they have a controlling interest in, that would be called a CFC company, or even a trust, which they have transferred assets to, that would be a transfer of trust. It can make an Australian resident person taxable on that income on an accruals basis. And what that means is that they can be taxed as that income is generated and accrues, even if they don't repatriate or bring it back to Australia. Now, the CFC rules, the transfer of trust rules, they're very complex. They're subject to a number of exceptions, and those are pretty important exceptions. But I think the key message there for everyone listening to us is that the Australian tax net can be cast very, very wide, and you can have a liability to tax in Australia on money that's made overseas, on assets that are overseas, even where those assets, that money, is not repatriated back to Australia.
And Frank, what if those clients want to close down their offshore companies and trusts and bring the money into Australia? Can you just touch on what the tax issues might be and maybe the timing that they should be thinking about?
Sure, Todd. And very often that's what clients want to do. More and more clients are looking to avoid this complexity, or if they do have assets overseas or income overseas or businesses overseas, they may be wanting to bring some of that wealth into Australia and into the Australian tax net, and invest in Australia or diversify their risk away from overseas countries where their assets might be more volatile, or they may be exposed to more volatile political or economic environments and so on. So a lot of the time, what people want to do and what we help people do is actually bring their wealth back into Australia, which is driven by their commercial and family needs, not really any tax planning. But from a tax point of view, again, sort of sounding repetitive, but it is important to have a planned approach to these sort of steps, or the steps you would be taking to bring wealth back into Australia. The ATO is looking at very closely at distributions from offshore trusts, especially. In recent weeks, the ATO released some guidance about Section 99B. That's a whole presentation in and of itself, and indeed we have done a webinar which is available on the Hall & Wilcox website if people would like to tune into that and view that as well, which is a whole 1 hour and 20-minute discussion about 99B. But very simply, what 99B is about is making Australian residents who get distributions or payments or gifts or any sort of financial benefit from an overseas trust taxable in Australia as a basic presumption or proposition, unless they can again argue their way into a certain exception. So, and that's an exception that applies for capital distributions, unless that capital has its origin in money that's been accumulated overseas tax-free. So a hard thing to explain. I do encourage those listeners who want to learn a bit more about 99B to have a listen to our webinar on the Hall and Wilcox website. But again, it's important to have a plan. It's important to understand the risks. It's important to manage the risks, and it's important to get good advice.
Thanks, Frank. I think just continuing that thread there about bringing money in from overseas, a lot of our clients, rather than getting money out of a trust, they might receive gifts from overseas relatives, or they might get bequests from the deceased estates of their relatives. Can you just quickly run us through what are the key things to be aware of when you're looking at receiving this money from overseas?
Sure. So, I mean, this happens a lot, and we see this all the time, Todd. I mean, we might have a client, an Australian resident. They've lived in Australia for a long time, even maybe a short time, live their day-to-day life here. But, maybe they have a wealthy family overseas, or their parents or other family members are overseas, and they want to provide their the person in Australia with some financial support, to buy a house, to buy assets, to start a business, to invest assets in Australia on behalf of the family, and so on and so forth. There are a multitude of reasons why people are motivated to bring money into Australia, and when that happens, and especially if it's big dollars, let's be honest, if somebody's buying an expensive house somewhere in Australia, in Sydney or Melbourne in particular, we could be talking about millions of dollars, if not tens of millions of dollars, that are being that is being sent to Australia. If it's in a family context, and if the explanation for that is that it's family members overseas providing a gift or providing a form of family financial assistance to a person to help them buy a house or assets, etc. I mean, that's perfectly fine, but it's always important for people to remember, if the ATO questions that, well, let me take a step back. A financial transaction involving an inflow of money from overseas to Australia of that magnitude is going to raise a red flag under AUSTRAC, if nothing else. If that red flag is raised, the obvious question for the ATO to ask is, well, what is the source of that amount? And in particular, does that amount relate to an amount of income that you derived overseas as an Australian resident and you should have paid tax on, but you didn't? If the client's explanation to that is that no, it was a gift and intended as a gift that came to me from a family member overseas, it becomes your job and your duty as the taxpayer to prove that that's the case. We have the reverse burden of proof in tax, so it's up to the taxpayer to show that that's a fact. And of course, in families, things are often done and can be done informally. They might not be documented to the same degree as you would have in a transaction with an unrelated party that's hotly negotiated and contested and so on and so forth. So, again, I think we have to be encouraging and counselling our clients, and all advisors do, to approach these type of transactions, even if they are occurring in a less formal, family type of context, to be documented, with some formality, so that clients and the recipients of money can demonstrate to the satisfaction of the ATO and to the standard of the burden of proof that these amounts, be they a gift or something else, are what the client says that they are.
Yeah, and I think part of that, Frank, to my mind, is not taking things at face value. There'll be clients that often say to us, yeah, I've got a gift from an overseas relative. Gifts are gifts subject to tax? And the easy answer to that is, well, no, gifts aren't typically subject to tax. But when you actually ask more questions and you start to look into it, it turns out that this wasn't actually a gift from a relative. It was money that was pulled out of a trust or money that was pulled out of a company. And that can have very different tax outcomes. But unless you ask those further questions and unless you try to dig just a bit further to get to a proper position on this, you're not going to know that. And that's going to be just a tax risk that's sitting in the background there that might actually be raised by the ATO at some future point. And it's better to get ahead of it and figure out what's going on rather than letting it sit in the background and potentially come to light in future. So Frank, if there's a client or an advisor who's listening to this and thinks it all sounds familiar, they might have a new client who's just come in from overseas, or an existing client looking to go overseas, or there's offshore structures. What can they do and what can they chat to their clients or their advisor about in order to manage those tax risks?
Sure, Todd. Well, there are a few things, and I'll talk about what's most important. The first is the issues are complex, so get proper advice, and get proper advice on both sides of the fence. So what I mean by that is you may need Australian advice, but you may also need advice in the country where the person is, or where their family is, or where the assets are, because we don't want to have a Australia-centric view of tax issues and miss what might be a horrible consequence for somebody from a tax point of view in another country. The second is things including arrangements between family members should be documented properly and thoroughly. And it is often that documentation which will serve as your evidence or evidence trail to allow you to prove to the ATO satisfaction that things are what you say they are. Again, we're getting repetitive, but the third point is to act early and to try and get ahead of issues and take action before the facts are set. Once things have happened and once the facts are done, they cannot be undone, they can't be unseen, and you might find yourself being reactive as opposed to proactive. So it is important for clients to engage with their advisors as soon as they possibly can, preferably before any steps are taken that might set their residency one way or another. Easier said than done, because it's not always up to the advisor to do that. It might be up to the client, but that's what we would all be hoping for. And then in some cases, the issues can be so significant or so material or so unclear that that it might be important to start thinking about what strategies you have to try and formally mitigate some of that risk. So what I'm talking about there, Todd, is your client has a complex issue and may want some compliance certainty. There are avenues through which you can engage with the ATO to achieve that certainty, or at least some assurance, and allow your client to proceed and manage their affairs with higher compliance certainty. That may be getting a private binding ruling from the ATO, but with a private binding ruling, it's always important to get the facts absolutely clear, because the ruling is only binding on the facts that are presented. The ATO is very good at engaging through an early engagement process with taxpayers and providing a degree of administrative assurance through that. Or there are options that do not involve engaging with the ATO, such as setting out positions in a reasonably arguable position paper. All of these things, all of these tools are ways of helping our clients to manage and mitigate some of these risks.
All right. And what if a client or the advisor, they've had a look at all of this, they've had to think through the issues, and they realise that they do actually have an issue? Maybe there's some undisclosed offshore income or assets. What are their options in that case?
Sure. Well, and I mean, this happens a lot. This area of law is, so complex that it's not uncommon for mistakes to have been made or for things to have been missed. And that's very often when we're called in to help taxpayers try and address these things. They're very often issues that come up when a person changes accountants, or when otherwise, there's a fresh set of eyes looking over what a taxpayer has done. I mean, the advice we give, and I think it's the responsible advice, is to encourage taxpayers to engage with the ATO. It's never a good idea to stick your head in the sand and hope that things go away, or hope that they'll never be picked up. The best way to approach an issue like this, be it having income offshore that hasn't previously been disclosed for whatever reason, having assets offshore that aren't disclosed as an interest in a person's tax return or anything else. The best way to address that is by way of a voluntary disclosure with the ATO. Again, this happens regularly. The ATO has procedures and people who can assist with these types of issues. Some years ago, back in 2014-15, there was a formal ATO amnesty for undisclosed offshore income called Project Do It. That's wound up, but the essence of that certainly remains in place, and it is something that is encouraged. And aside from giving your clients a bit of assurance that they can fix up issues from the past, there's a tangible benefit in making a voluntary disclosure, and that is that it can provide taxpayer with relief from penalties if they address past non-compliance or past non-disclosure issues through a voluntary disclosure. So that's always the path that we recommend, and rarely does taking that path take a wrong turn.
All right, thanks, Frank. It's been a great discussion. Thanks for coming along. And thanks everyone for listening in today. As always, please get in touch with us if you have any questions. Frank or I are always happy for a chat. You can find our details on our website, which is hallandwilcox.com.au, or you can connect with us on LinkedIn. If you enjoyed today's episode, then rate, review, or follow our podcast wherever you get your podcasts. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.